Hey everyone, stand up and welcome to the Note Investor Podcast. And today joined by Franco Barile from Sottile and Barile. So Franco, how you doing?
I'm doing very well. You?
Yeah, not too bad. Can't complain. So you're someone that I depend on very heavily, especially for all my Michigan, Indiana, and Ohio stuff. And I know you guys cover other states as well. So maybe start by giving us a little bit of intro on who you are, what you guys do.
Sure. I partnered with Tony Sottile back in April of 2015, and we're 4 years into the business. We came together as a creditor side bankruptcy and collection firm. I have decades of experience in collections. Tony had the same experience in bankruptcy, and we've always known how to do foreclosures, but our bread and butter was bankruptcy and collections. And it was in 2016 when we started taking on foreclosures again. We knew how to run them a little smoother than some firms. And what was nice about our firm is that we didn't heavily rely on these foreclosures, where if there was an up or a down in the cycle, we can continue with the market, allowing our other practices to to move forward as well. So we've been doing that now for about 3 to 4 years, and it's been going pretty good. I mean, we're in Ohio, Michigan, Kentucky, Indiana, and Illinois. So we've got the Midwest covered. And I know there's a lot of inventory in those states, but we continue to provide what I believe quality service. And depending on what the client needs, we can pretty much do everything on the creditor side.
Yeah, that's good. Yeah, that's where most of the notes. That's like the sweet spot for notes.
Yep.
In all of those states. And I know you guys have done quite a bit for me, mostly on the foreclosure side, and then a little bit on the bankruptcy side.
Yep, and transactional too. I mean, we are able to prepare land contracts, notes, and mortgages. We've been able to convert land contracts to notes and mortgages, and the benefit of that is getting the investor's name off the property for maybe certain properties that have too much risk involved. Kind of just take yourself off the property, give it to the borrower. Now you've got a note and mortgage. Yes, you're going to have to foreclose if they default, but overall, you're not worried about that liability on that property.
Yeah, which is nice. And I haven't done one of those yet, but I know we've talked about it.
Yep.
On a few. But it's nice too, because when you do go to if you do go to resell it, typically mortgages sell at a little more of a premium compared to contract for deeds. So that can be help. You can kind of recoup your costs.
Absolutely.
And some that way.
Yep.
Very cool. So I think you had a presentation you can bring up.
Yeah, so what I'll do is we'll share a screen here.
Yeah.
Let me share this here. And then,
cool.
Right. So what I'm looking to do today is just go through the new rules and regulations in Ohio. I see I already spelled regulations wrong on the sheet, so I'll have to update that. But Ohio is the main state at the end of 2018 that really kind of shook things up, and it made it difficult for investors. It made it difficult for lenders who wanted to stay in Ohio. They need a new license. So there's been licensing requirements. There's new requirements for second lien holders. And one of the final things we're going to talk about is the new land contract bill in Ohio that's going through the committee. There is no activity as of today. There are some committee meetings, and they had some testimony. I actually thought that bill was already going to be passed by now, but it looks like it's kind of slugging its way through. So it would be nice if it didn't pass, but if it does pass, there's a lot of things you need to watch out for.
Now, this would be good, because I have a lot of people call me and ask me about Ohio, and I just kind of refer them to you, because plus I know a lot of this stuff is kind of in flight anyway. So this will be good, because then when people ask me again, I can just point them to this recording.
Absolutely. Yeah, you can point to the recording. I could also share the presentation with you all, and of course, with a presentation, you're not always able to see everything involved. So you always have my email, phone number. We can talk about things as well.
Yeah, that sounds good. If you send me this afterwards, I can post a link to it when I send my newsletter out too.
Excellent.
If you want to get to it.
Okay, so I tried to jazz things up a little bit. So if people who are watching, at least when they get a chance to it, it excites them a little bit, because sometimes when you hear an attorney talk, you kind of drown them out. So at least you got some pictures here you can look at.
Yeah.
So basic crux, what happened in Ohio in 2019? Ex-governor John Kasich is no longer a governor. He signed a lot of bills into law at the end of 2018 during the lame duck session. It's not very typical for a governor to do that on the way out, but he did sign a lot of bills. And on his way out, he made it more difficult for note investors to continue their practice of buying notes without a license. So those two major bills that were introduced into law were due to House Bill 489. And that bill had a lot of different things going on, but the two major pieces came from licensing requirements and what to do as second lien holders. So first, the new law adds a licensing requirement. The new law had amended a section 1322.07. It required servicers to obtain a certificate of registration from Ohio's Superintendent of Financial Institutions. Well, you say, oh, servicer, that's not me. I'm a note buyer. I'm a note investor. No need.
Right.
Well, we were waiting for guidance from the Ohio Department of Financial Institutions, and they finally came out about 2 months ago. And the main question at the bottom was, what about note buyers? And flat out, they said, if you are buying notes and mortgages, you must get a license. The reason is they believe that when you buy the note, the minute you buy it, you become a self-servicer. So
even if you hired a servicer, that's just the way they view it.
They view it the minute you buy it, you're self-servicing. There's no way around it. But what I have found through other investors is the fact that the process is not that bad. We've had a couple of investors already go through that process. It's I put a link there. It's the nationwide licensingsystem.org. You go into that site, you click on state licensing requirements, and it gives you the whole country. And you get to pick and choose which state you want to look into for licensing requirements. Of our states, Ohio, Illinois, and Kentucky. Those are the three that require some sort of license. Mm-hmm. Kentucky, I don't even want to talk about today. It's too onerous and way too expensive. Illinois is not that bad, but there's still a yearly payment you have to make. Ohio, I'm not so sure about yet on the payment. I know it's not as expensive. The process isn't as onerous, but it's still pretty tough. But if you go to that licensing system website, you can pull the application off of, it'll say 1322.07. You pull the checklist, print it out. I think it's about 10 pages. It's a lot of things that are personal to investors. Those aren't things we can answer as a law firm. So that's why we don't do these for our clients. Right. They ask about all kinds of things, profit and loss, criminal background checks, accounting procedures. But as of March 18, 2019, if you're going to be in Ohio and you're going to be buying notes, you have to have that license.
No, it makes sense. Yeah, and the Illinois license is one that I've thought about from time to time, but I haven't actually done it because I've been able to find enough stuff in my other states. Plus, that state just always scares me a little bit for some reason.
It does. It should scare you for a little bit, but you know what? We've been doing it now for about 1.5 years. We've got 2 very good Illinois attorneys who've done this for a long time, and we haven't seen many issues. We started our first case in April of 2018, and it was Cook County. Mm-hmm. I'm sorry, July of 2018, and we got a sale in April of 2019. So not too bad. You're looking at.
That's good. You guys are actually. It's funny. I don't buy notes in Illinois, but you guys are actually doing a foreclosure for me there because I did a loan out of my self-directed IRA that went south. So we'll see how that.
So we'll see how
I'm getting a little bit of experience, anyways, even though I didn't intend it or expect it.
Yeah, you know what I mean. When it comes to Illinois, people do get scared about it, but again, the attorneys we have, they're very experienced in what they do. And we've got great staff. They're on top of everything. If a borrower doesn't respond, you're smooth sailing. And even if a borrower does respond, it just delays it a bit. But it still isn't as difficult as it was years ago.
That's what I have going on in this situation. The borrower hasn't responded at all. And it's really weird because it's not my normal borrower. This is a lady here in Colorado who's a fairly well-to-do real estate investor. So it's just really a bizarre situation. So we'll see how this pans out, but so far so good.
We'll see how smooth it goes.
Yeah, but then on this one too, I think your last point here was that this doesn't apply to land contracts in Ohio, right? No,
this is just for notes and mortgages. But that's okay. We got a whole slide just on land contracts that'll make you uneasy. So as far as licensing land contracts, no, you do not need that. Okay. Second class, these are for your second note buyers. House Bill 489 implemented new requirements for collecting a debt in default, and it's a junior lien on real property. So if you've got a second lien on real property, you must send a notice to the borrower, and in it shows the notice must state these certain items. Name, amount of the debt, state that the debtor has a right to an attorney, and then some bankruptcy issues for them to realize. Once you do receive a written request, you then have to start, responding with the, copies of notes and mortgages. It does not allow for class action status, which is good. So if you do this, 100 times over and you get it wrong 100 times, it's an individual case per person. They can't bunch them together. But this notice does state that every party collecting a debt. So if you are the note buyer, immediately you must send this notice out. If you give it to a servicer, they have to send the notice out. If the servicer sends it to a law firm for collection, we have to send the notice out. It is so backwards. So, and I also believe this may be in contravention to the FDCPA. So I'm wondering if maybe the CFPB is going to take notice of this new statute eventually, because it goes against the FDCPA verbiage, and it really is nonsensical. I don't know what the point of this notice is, because if you're going to collect against somebody who has a second lien, or you're going after the borrower with a second lien, you're sending them a demand letter anyways. Why do you need to tell them that they can get an attorney? It's so backwards, but they're doing it. Yeah. It's in the law now. So we have been able to craft a letter for servicers on their behalf, on their letterhead, saying, hey, look, this is kind of how you want to make it look. And, kind of reviewing some of these letters that we're getting from servicers, from investors, saying, hey, does this notice look good? And then our own end, we have our own little template regarding these type of notices. So anybody who refers a second lien, this notice is the first notice that goes out, along with an FDCPA notice. And then eventually, if you're going to file, the foreclosure or suit, you can then file after 30 days.
Mm-hmm. And I probably should ask this earlier, but what was the problem Ohio was trying to solve with these new rules? Were there some incidents, or like what was the genesis of all this?
This one, I don't know. This might be more policy reason to try to remove second lien buyers from Ohio, saying, hey, we've got more regulations. Don't bother with Ohio. It's not that bad of a regulation. You have to it's a one-page notice. But the policy behind it, I've been trying to search for it. The licensing requirement, I believe the policy behind that goes along with Kentucky. Kentucky made it very difficult for note buyers. And what they want, they want traditional lenders. They don't want individuals coming in, buying this paper, and then not knowing what they're doing and just start filing suits and being what they call bad lenders. When, in fact, the reason we had the recession, the big one, was due to the big lenders. So it's very odd on why they want to do this, but I haven't seen any reason why they decided to do it. They're just trying to make it tougher for individual investors to create a market in Ohio.
Yeah, it's not like the financial crisis was caused by people who bought their loans on paper stack and stuff, right?
Right. It's pretty amazing, but they, I guess they have to prove their reason for being a legislature, right? They have to say, hey, we passed some bills this year. Well, okay, but they don't make any sense.
Right.
So they are making it a little difficult. I apologize for that. I thought I had this on silent.
Excellent.
All right, so we got the licensing requirement on the House bill. We got the second lien holders basically take notice. And so Ohio passed more laws affecting investors. So the current statute found in 53.13.02 allows for seller financing and has some necessary language to include in land contracts. So House Bill 103 just amends the current statute. The current statute really didn't have much beef. It just stated, to have a land contract, here's 10 things you need to have in it. And then at the very bottom of the statute saying, well, if you substantially comply with the statute, it's a land contract. Because guess what? If it's not a land contract, what is it? Some lenders have said, hey, well, then it's a month-to-month lease. And that then affects the tenant, the borrower. So that's kind of why they put the provision in there. If it looks like a land contract, it smells like a land contract, it's probably a land contract. Mm-hmm. Well, this new bill is going to, what I believe, eliminate land contracts. And the reasons are proposed here. One, the seller is responsible for the payment of property taxes, property insurance premiums, assessments, and other charges against the property from the date of the contract. That's the biggest reason why you want to give a land contract, is so that the borrower, the buyer, pays for the taxes. The buyer pays for insurance. Not anymore. So basically, a land contract is now just a glorified lease.
Mm-hmm.
And I say now, but it's a bill. It hasn't passed yet.
Right. And if this passes, would this apply to just new ones created after it passed, or would it?
There's nothing in the bill currently about retroactive status, but I believe it'd be unconstitutional to have retroactive ability on this type of bill. So we're going to keep an eye on it. When the bill finally passes, it's probably going to give it a date certain, from the date of the bill, which I believe. I believe it'll be a start date. The bill passes January 1st, 2020. From there on, any new land contract thereafter must abide by this land contract. But we'll go through the next slide of why I believe there may be a touch of retroactivity, and you'll see why. Number 2, sellers responsible for repairs and maintenance on the property. The seller shall not hold a mortgage on the property. A copy of the land contract is provided to the purchaser, and the requirement that the homeowner's insurance must be obtained on the property. So it's a note mortgage. It doesn't make any sense. And the repairs and maintenance, you're a landlord. You are now a landlord. You're no longer seller financing land contract vendee. You are a landlord, because a landlord is responsible for repairs and maintenance. Now, the seller can't hold a mortgage on a property. I don't know where that's coming from, but that's
strange. I don't get that, but at this point, if you weren't going to do a mortgage, I guess you would just do a lease in this case, because you're a landlord anyways. You
are, and the reason you're going to want to do a lease instead of a land contract is this. So it gets worse. The seller also has to pay off any liens on the property prior to executing a land contract. The seller cannot place a mortgage, as we discussed. They must comply with requirements of any building codes. The seller must make all repairs. The seller must contact the local building department for code enforcement to conduct an inspection. If the inspector finds a violation, the seller must fix it. It's basically point of sale. You have to get a certificate from the building department, and prior to executing the land contract, the seller shall obtain and pay for an appraisal. I mean, this is insane. So these are the big ones. Now, 1 through 8, some of those are part of that first slide, but these 8 provisions right here are going to make you say, forget it. I'm not going to bother getting into a land contract. Every time you enter a land contract, you need an inspection. Every time you enter into a land contract, you need to get an appraisal. I mean, this is gone too far.
It's like they could have just saved some space and just had one thing that said no land contracts in Ohio.
Yeah. They've been officially eliminated. You might as well.
Yeah, just cut the point. Yeah.
So all they did was throw a bunch of regulations together, slap them on a statute, and say, all right, no more land contracts. So right now, the key is it's called House Bill 103. It's not called Revised Statute 5313. So it is going through the committee. They had a major hearing in May of this year where a lot of local legal aid attorneys appeared, a lot of attorney generals. They all came on board and kind of detailed the reasons of why they wanted this statute. Now, the city of Cincinnati and the city of Youngstown already have pretty stringent requirements when you do buy into those areas regarding inspections. So the Ohio House stated, well, if every city is going to provide an ordinance like this, let's just have a statewide ordinance. So that's all that this is. It's an overhaul of the statute. And if it does pass, we'll let everybody know right away. And I believe it does eliminate that idea of going through land contracts. But for the time being, it's just a bill. So it may not pass, and we will definitely keep an eye on this bill. I've been checking once a month, and the last thing that happened was back in May. So they're still through the committee.
Oh, wow. That's a long time. At least they move slow. Yeah.
They do. I was a little worried they'd move a little quicker on this because of the bipartisan. It's a Republican and a Democrat that brought it together. For me, that's like the death knell. You're
that's
done.
Pretty tough. Yeah,
So we'll have to see what type of lobby there is on the lender side.
Do you know, has like Eddie Speed's Seller Finance Coalition done anything with this? I had Bob Repass on a while ago, and we're talking about stuff at the national level. I didn't know if they actually got involved at state levels at all anywhere.
I'm not aware of that yet. I haven't seen any rumblings at all. What I fear is that this just kind of goes through the process and gets passed, without any objection, without anybody lobbying against it. Because it used to be House Bill 378, and they changed it to 103 because the old House bill was just brought by a partisan group. I think it was the Democratic Party brought it together. But now they just said, let's get rid of that one. 103 has bipartisan approach. They think that's going to work better, which I do believe will probably work.
Right.
So that's the update on land contracts, and that's it. It was a small, just slides on the three biggest things that I've seen so far. We're seeing major changes in Ohio, and the two things we mentioned today are already part of the statute, and the one regarding the land contract issue is we're going to keep an eye on it and see if that does eventually become law.
Yeah. So are there any similar things being considered, of in places like Indiana or Michigan, or are they still kind of?
No, there's no current bill that's open or pending. If you're looking at states, you're looking at Michigan as being your most, what we call, creditor friendly. There is no bar in filing a forfeiture for a land contract. So if the borrower paid 90% of the purchase price and there's still 10%, just basically 90% equity, you can still forfeit the contract. Now you have to give them more time to redeem. You give them 6 months to redeem. But my goodness, I mean, it's Michigan is creditor friendly. You go in there, you want to forfeit the contract, you forfeit the contract. Ohio, there's that 5-year 20% rule. In Indiana, they have a quasi 20% rule. So Michigan's your easiest if you're looking to forfeit a land contract. I'd say Indiana's right behind there and number 2 in forfeiting contracts. But as far as changing the land contract scheme of things on how a land contract should look, no. Ohio's the only one that's really making a big push.
Yeah, that's interesting because I have, my in-laws are from Michigan. I spent time there, and I've always had this perception of it as kind of a more like bureaucratic type state. But in this area, they're really good to work. They've been really good to work with.
Yeah, it's a very easy state. When we file these forfeiture actions, we file, and plus there's a 15-day window instead of a 30-day window. So you give them a 15-day notice of forfeiture. Day 16, we're mailing the complaint. We have a hearing 3 to 4 weeks later. And then you get your judgment for possession. The only thing you have to worry about is that there's a 3-month redemption. So you have 3 months to pay the reinstatement, but they only have to pay the amount of the judgment. So if they pay the amount of the judgment, let's say day 60, but they're still 2 to 3 months behind because they haven't paid, post-judgment, you have to re-forfeit again. You have to refile the complaint.
Yeah, there was one you guys did for me where we went through the cancellation in Muskegon, and then they were in that redemption window, and the borrower owed like over $4,000 to reinstate, and then she did it, which I never would have thought, given everything that had transpired. I mean, I would have bet $2 million there's no way they ever reinstate, and then she did, and then started making payments.
Oh, she did.
Yeah,
very
good. Made at least the last 3. I got to check.
Yeah, that's
I don't want to jinx it, but
yeah, it's the one downfall in Michigan is if they do pay, technically they're supposed to keep paying under the contract too. But a lot of them do the system. They reinstate. They sit back another few more months. Maybe they save some money. So that's why in Michigan you might want to wait if they're in default. Maybe wait 2-3 months. Yeah, because you try to default them after the first month, and they only owe like say $800, and then the reinstatement's like $1,900. Well, they might come up with that, but $4,000, that's pretty surprising. I mean, that's the
that was huge. And so now I guess, she's got some pretty big skin in the game because she's not going to want to, get forfeited on again a couple months after that. Obviously they wanted to stay. So that was one of those shocking ones to me that I would not have expected at all. So, and then maybe you could talk a little bit more about, mentioned a little bit about converting contract for deed to note.
Yeah, so if
how that works.
Yeah, it depends on your business reason to do it. But if you're looking to remove your name from the deed and you want to just flip it to a note and mortgage, what we do is we prepare a release of land contract. And again, you're going to have to negotiate some terms with the borrower, but you can just tell them, look, here's what's due on the land contract. We'll just create it and convert it to a note and mortgage. So you release the old land contract. We prepare a deed. The property gets transferred over to the borrower. The borrower signs the note and a mortgage. You record the mortgage, and now you are a traditional lender. I will caution, though, if you start converting some of these land contracts to notes and mortgages, they may be considered originations. So you're looking at Dodd-Frank. You're looking at using an RMLO. So if you have someone who has a mortgage, mortgage loan originator license, if you know somebody who does that and can help you as you start to convert these, then you're fine. But if you're doing more than 3 in a calendar year, you're going to want to use somebody with an MLO, or you might want to get licensed as a registered MLO. And that's the one downfall of converting them, is how many you're going to do.
Yeah, no, there are like certain lending standards you have to comply with and all that. Because I would imagine there might be some cases where you run into cases where you can't do that because the borrower doesn't qualify because they wouldn't.
Yeah, we've had some where the MLOs come back and said, this is not a good deal. We've gone through the whole process and it's not feasible. And but the majority of the ones we've seen that we've converted, the MLO takes care of everything. They take care of all the paperwork that's needed for the onboarding process. But the preparation of the legal documents, the deed, the mortgage, the note, and the release of land contract, we prepare those. So we work in conjunction with the investor, and the investor works in conjunction with the mortgage loan originator. And between the 3 of us, we wrap it up, go ahead and record the note, mortgage, and deed. And then, again, you become a traditional lender, which I know we discussed before. You can probably get a better price on a note and mortgage than you can in a land contract.
Right. No, that's good. Yeah, because like I said, I haven't done those yet, but that's something I'm probably going to be looking at. And then you had mentioned too that there could be a retroactive component somewhat to the existing contract for deeds. Like, what are the things you look out for with those?
And you know what I'll do? Let me go back to the previous screen here. It's going to be the way I think retroactivity may apply. I would look at bullet point number 5, and I would also look at, I would go from 5 to 8. Those seem like items where if you don't have those things, if you didn't, get a certificate from the building department and you didn't, have an inspection conducted, it's very possible those could have retroactive capabilities. So they may come out and say, you have a land contract, you must do this. Maybe they give them a window of time to abide by the statute, 30-day window. But that's the only point I can see where they may make it retroactive. But if they don't, then it's going to be all new land contracts. Any new land contract from the date that the House bill is passed, you have to make sure you go through 1 through 8. Yeah,
it's funny. I've had various cities tell me I have to have inspections done and different things in a variety of states. And so far, I've been able to argue my way out of all of them. I know some people have done them, but I've got some little systems to try to push back on those, and knock on wood. I mean, eventually I'll be doing them, but so far I've been able to avoid doing those.
Yep.
Which is kind of nice, but cool. Well, hey Franco, well, thank you so much for coming on. I really appreciate it. It's definitely a topic that I get a lot of questions about, so I know it's something that a lot of people are concerned about, and there's just always a lot of uncertainty around where things stand. So that was good. Yeah, and
you want me to do this again? No problem. We could pull up some different things that are happening in different states. If anything, it'd be a 101 on how to do a forfeiture, or what we look for in title and stuff like that. As far as new rules, new regulations, Ohio's the hot state, and I haven't seen much yet from other states. It could happen, but we're gonna have to wait and see. So far, let's keep an eye on Ohio and see how this all comes down.
All right. Well, sounds good. Thanks a lot.
All right. Take care, Dan.